Great. Okay, well, welcome back, everyone. And let me see. I actually am, I've sent back a number of papers, I know, and I am working my way through them. So I hope by next week, actually, Karen just gave me a batch of papers for you folks that I will read and give back to you next week. And other folks will be getting them via email. And thank you for pointing out to me the various problems with the website, which I hope now have been mainly resolved, although it's still kind of a mystery to me. Is anyone still having problems with it? Maybe I should have asked before you raised your hands. Okay. So let us see where we are then. Last time we finished up, how did we finish up last time? 11 states ratified, which is enough to bring the thing into effect. North Carolina rejected the Constitution. Rhode Island had rejected it at the town meetings in the spring of 1788. And so 11 states were enough to make the thing happen. And so Congress notified the states. Congress went out of business, and the states then began the process of choosing presidential electors, the method of which was left to the states, as well as having congressional elections, and the state legislatures also chose United States senators. And in March of 1789, this government convened in New York. And Congress met very quickly. James Madison became the leader in Congress. Madison was a brilliant legislator and set to work essentially seeing the kinds of things a federal government would need to do. There were going to need to be executive departments. And there were executive departments, in fact, under the Confederation. What kind of executive departments, would you imagine you would need in a government like this? What are the kinds of things the government has to do? There has to be a treasury. That's the big thing, of course. And this was the one to which the Congress devoted the most attention. Setting up a department of the Treasury. Now, the Constitution gives the President the power to appoint these various officers. Some of them have to be confirmed by the Senate. The Secretary of the Treasury would be answerable to Congress, as well as actually more so to Congress than to the President. And they don't say, okay, we're going to have a cabinet. That's something that emerges gradually. We'll get to that in a bit. So a treasury, a department of the Treasury, which would oversee the finances and so on. And there would be a treasurer, as well as a secretary of the Treasury, a treasurer, and a number of clerks. And by far, this will be the biggest part of the federal apparatus, really up until the Civil War. Okay, so yeah, we need a treasurer. Anything else? A War Department, okay, and in fact there was a War Department under the Confederation and oversee the Army. There really isn't, the United States had actually sold its last ship in 1784, so there's not a Navy at this point, but there is an Army. Okay, anything else? A Secretary of State. This is going to be a bit of a problem. Yes, there's a Minister of Foreign Affairs under the Confederation. John Jay is Minister for Foreign Affairs. And so there is an acknowledgement that the United States will have foreign affairs that will be conducted by a Minister for Foreign Affairs. The Constitution also set up some internal functions of the federal government. Things like patent laws, uniform weights and measures, these kinds of things. Now, should there be, in England there are lots of secretaries of state for various things. Should there be a secretary of foreign affairs and then someone else whose job would be internal things? Do you think? Excuse me?
I think it'd be better to have two separate people.
Okay. two separate people so that the guy who's handling the diplomacy isn't tangled up with weights and measures and that kind of thing. I can see the merit of your position. However, if you insist that you've created a government of limited powers, are you then going to have a full-time official whose job it is to look into internal things he can do? We all acknowledge, yes, the federal government will handle foreign affairs. We haven't agreed the federal government is going to handle all of these internal things that are state responsibility. So if you have someone whose job it is to do those things, well, he's naturally going to be looking for more things to do. And this would imply an expansion of federal power. So what the Congress does is create, not that yours wasn't a good idea, but now we know which side you're going to be on in the rest of this discussion tonight, a Secretary of State whose job would combine both foreign affairs and whatever other small, domestic things might need the attention of the federal government. So the Patent Office will be in the Department of State. Weights and measures will be in the Department of State, and other functions you might not expect to find in a Department of State. But if you don't want to create the vast federal bureaucracy that you're going to need, if this guy's also, you're going to also have people looking into various domestic things, that's all you want. Okay, so three executive offices or departments created by the Congress. The Treasury, by far the biggest. The state, this guy gets to hire some part-time translators and a clerk. This guy also gets to hire a couple of clerks, overseeing the military affairs and other things we'll talk about. And then anything else? See, we're all satisfied with a federal government that just does these three things, which is good. I'm glad that all of my preachings have borne fruit so far. Yes? Attorney General. That's good. And you actually phrased that the right way. They do not create a Department of Justice. They do create the Office of Attorney General. And his job will be to attend to any legal business that comes up on behalf of the federal government before the federal courts. This is a part-time position in 1789. He's not supposed to go out looking for lawsuits to file. If a case comes up, he is supposed to handle it. And President Washington, when he appointed the first Attorney General, notified him it's a part-time position, and and you'll have plenty of time to attend to your other legal business. It's not going to take up a whole lot of your time. So Congress creates these executive offices, and things go pretty smoothly. Does anyone know, by the way, who Washington appointed to these various positions? State was Jefferson, right, but we have to put a footnote there. Jefferson was a brilliant choice for Secretary of State. 1789, Jefferson is American minister to France. He remains in France until early 1790, okay? So the government set up in the spring of 1789. Jefferson is nowhere around. So John Jay, who had been Minister for Foreign Affairs, continues handling the functions of this office. Jefferson arrives back in the United States. He receives a message from President Washington notifying him that he has been appointed, or Washington has appointed him to be Secretary of State, and Jefferson immediately says, no thanks. I want to go back to France. It takes Jefferson a while to accept the position as Secretary of State, but he does, and it's a good thing for all of us ultimately. Okay, so yes, Jefferson first, but with a footnote, doesn't take office until about 1790. Anyone else? No. Who was Secretary of the Treasury? Yes, Alexander Hamilton. Okay, yes, also a very good choice. Had been an aide to Washington during the war. Brilliant financier, knew all kinds of stuff, and we'll talk more about Hamilton. Secretary of War, this is an easy one because he also was Minister of War under the Confederation. See, if you were from South Boston, you would know this. He's like our hero in South Boston because he brought the cannon from Fort Ticonderoga. And I believe he's the heaviest man ever to be in the cabinet, too. And in fact, he and his wife were the heaviest cabinet couple, at least during the Washington administration, maybe for all time. You can look it up and do that. Maybe I'll teach another course on quirky facts about people you've never heard of, since no one here remembers Henry Knox. Okay. And Attorney General, part-time job, Edmund Randolph, our old friend, the governor of Virginia. Now, each of these agencies functions separately, or each of these guys functions separately. They don't start meeting. They don't actually, this is a good thing to bring up. There isn't anything in the Constitution that says these guys are going to advise the president. The president can insist that they give him, advice from time to time, but Washington doesn't, appoint these guys expecting, okay, I'm going to ask these guys for advice. He knows diplomacy, yes, that's something that I will ask Secretary Jefferson about. Treasury, yes, that's something Hamilton. War, Knox. Attorney General, if there's any legal business, our old friend Edmund Randolph. But other than that, no, they won't meet as a group until about 1792 or 3. So it takes them a while to function together, not that they should function together as a group. I don't know, when you have these big cabinet meetings now, how much really gets done. Anyway, so to whom will Washington go for advice? His first idea is, well, read the Constitution. There are a number of things on which it says the Senate will advise and consent with the president. That is, the president can do such and such with the advice and consent of the Senate. Well, doesn't that seem to indicate that when Washington needs advice, he should go to the Senate? Well, sure. So Washington does go to the Senate for advice. They're negotiating a treaty with the Creek Indians, or maybe it was the Cherokee Indians, and so since the War Department handles relations with the Indians, Secretary Knox and President Washington draft a treaty that they hope to make with the Cherokee. Now, it stands to reason, since the Senate is the group that will ratify treaties, they should go to the Senate for advice before they go and negotiate the treaty, right? So the senators have convened. John Adams, who is vice president, presides over the Senate. And I should have pointed out, Washington spends several months trying to figure out to whom he should go for advice, and it never occurs to him that the vice president should be his advisor. Because Washington wants to keep the vice president at arm's length because the vice president presides over the Senate, and he sees an interference there, separation of powers, et cetera, et cetera. Okay? So he's not going to turn to John Adams for advice. However, the senators, yes, he will go and ask the Senate for its advice and consent. So Washington goes into the Senate with Secretary Knox. Secretary Knox sits down. Washington stands in front of the senators with the treaty, and he reads Provision 1. And he reads it, and he looks at the senators and says, "Do you advise and consent?" And this is pretty much the response Washington got. They looked at him. They wouldn't answer him. And he kept reading, asking, and Washington mastered his temper throughout his life. It's one of the great achievements in Washington's life, mastering his temper. This is one occasion when he lost it. He said to the senators, "Why aren't you advising and consenting?" And one of the senators raised his hand and said, "If you put this in writing and send it to us, we will deliberate over it and we'll get back to you in writing, but we're not going to advise and consent while you're standing here. And if we agree to something and you negotiate the treaty differently, does that mean we've agreed to the changes? So put it in writing and we will get back to you." And Washington loses his temper, throws the papers on the floor, storms out saying, "This defeats every purpose of my coming here. I am not going to ask you for advice again," and off he goes. And the senators have established something pretty important, that they're not going to be the president's advisory body. They're going to be somewhat independent. Washington is left with a bit of a problem because he doesn't have anyone who can advise him. He and Knox work out the treaty, and then they send it to the Senate in writing. Yes?
Professor, but sure, he has the vice president,
He does have the vice president, but he doesn't think the vice president should be advising him because the vice president's job is to preside over the Senate. So Washington sees him as a legislative officer, and it would be a violation of separation of powers for the head of one branch of government to be colluding with another. The whole body, it's a bit different. Okay, so yeah, and Washington and Adams don't really get along that well. Yeah, that is a problem, I suppose. Next, Washington thinks, well, why not John Jay? Jay is acting as Secretary of State. He also has been appointed Chief Justice. And there is not a whole lot for the Chief Justice to do, or for the other judges on the Supreme Court. You can imagine there's not a whole waiting line of lawsuits coming before the Supreme Court in its first session. So Washington thinks, John Jay, great advisor. Yes, Jay is one of the wisest men in America. And so Washington calls on Jay for advice, and Jay says, hold it right there. If I give you advice now on this matter, and if this matter comes before the court, that would mean I had already decided the case. So you'd better not ask justices on the court for advice, because what we can do is render decisions if something comes before us in a case, but we can't give advisory opinions. Very important precedent that Jay establishes. Washington does not lose his temper with Jay. Jay is a very mild, conciliatory man. As I said, he was one of the wisest men in America. And Washington sees his point, that you can't go and ask a judge for advice, because then the thing might come before the judge. He will have pre-decided the case, and you don't want that. So the court is also out as an advisory body. And in fact, the court remains. There's only been, I think Abe Fortas was the one justice who gave the president advice, and that's because Lyndon Johnson always had turned to him for advice and thought just because he was on the Supreme Court it shouldn't change that. The other justices didn't like it. So anyway, Jay says, no, we're not going to give you advice. And this leaves Washington, of course, with no one else to whom to turn, so he turns to these guys, the executive officers. Okay? Any questions on this? Yes?
One quick question. You mentioned that Washington and Adams didn't have a good relationship when Washington was the president, but they did have a good relationship early on.
Well, yes and no. They were in different spheres. Adam, what do you mean they had a good relationship earlier on? By the way, you may know more than I do.
Was here in Boston. I mean, seems that...
Yeah, okay. Adams and Washington had a great respect for one another. Let's put it that way. Adams had nominated Washington to be the commander of the military forces because he knew you needed a Virginian, and Washington was the most likely candidate. So that was a good thing. And Adams did more or less support Washington. The New Englanders actually, several times during the Revolution, tried to oust Washington as general. So there's a bit of a suspicion there. Well, there's a great quote of Adams's. The history of our revolution will be told as one lie from one end of it to the other. The story will be that Dr. Franklin smote the earth with his stick, and out came General Washington. And that Franklin then electrified him, and the two of them carried through all war, diplomacy, politics, and legislation. Okay, so Adams was jealous of a lot of people, and one of them was Washington. Okay, and I don't think Washington had a good personal relationship with anyone. He had good relations with lots of people, but in a certain way. Lafayette, Hamilton are like the sons Washington never had. Okay, so that was the kind of relationship. A relationship of two peers, no, Washington doesn't really have that. And in some ways, that's a good thing. In other ways, maybe it's not. I mean, we're not here to psychoanalyze these folks, but politically, there can be folks who get along, but they recognize the limits of this relationship. And maybe in this case, Adams and Washington are like that. We're not here to dissect the relationship and figure out, gee, maybe if Washington's mother had been nicer when he was a kid. His mother was kind of a difficult woman. As I said, we weren't here to psychoanalyze these folks, and here I am talking about Washington's mother, and I'm kind of embarrassed. So anyway, any other questions? You wanted to hear about the Constitution and not who got along with who or whom. Okay. So Washington solves this problem of advice. Actually, the person who really advises him most, the two people who really advise him most during this early term are Hamilton and James Madison, who is, of course, a member of the House of Representatives. And Washington knew he was the guy who helped ratify the Constitution, and Madison had been giving him advice anyway, and Madison really becomes the point person here. But this does leave, we'll get back to this because there's kind of an interesting bit about, a lot of things are happening in this first administration that are important in the long run. I'm not just telling you this because these little details are interesting, but because these things will have a long repercussions for all of us. Okay. Where were we? Oh yeah, so Adams is presiding over the Senate. Washington thought the Senate's job was going to be to advise him. It turns out that's not the Senate's job. Meanwhile, in the House of Representatives, James Madison is, creating the federal government, and also the second order of business, once all of this is done, is to draw up the amendments that are necessary for ratification. You'll recall the anti-federalists and others had insisted on amendments. And so once the Constitution is in effect, once Washington takes the oath of office on April the 30th, and the Congress has created all of these offices, Madison thinks now it is time to draw up amendments. Now, incidentally, this is just something I've learned in the past week. No one referred to the amendments as a Bill of Rights. I may call them a Bill of Rights during the course of discussion tonight, but Madison doesn't get up and say, hey, let's draw up a Bill of Rights. Instead, we need to make some amendments to the Constitution. Interestingly enough, when Madison first proposes this in Congress, Elbridge Gerry, who had opposed ratification, and one reason Gerry had opposed ratification was there's no Bill of Rights, says, no, this isn't a good time to propose amendments. Let's let the thing take effect first. Let's give it some more time. Interesting thing. I've always tried to figure out why Gerry then says, when Madison says, let's draw up amendments, Gerry says no. Perhaps it was because Gerry really hoped for a second convention, or maybe he just was afraid of what kind of amendments they would propose. Madison, though, has come to accept two things. One is that people really want amendments. Two, he recognizes that the price of ratification was this promise that we will propose amendments. And also he sees that having these amendments as part of the Constitution, notwithstanding Madison thought parchment barriers were ineffective, was people then can go to court if the government violates one of these parts, one of these amendments. Madison also thought the amendments should be incorporated into the body of the Constitution. Okay, so you have Article 1, Section 8, all of these things Congress can do. There are some things that people thought Congress shouldn't do. Article 1, Section 9 says that, so we'll put a lot of these into Article 1, Section 9. Roger Sherman, I think it was, said you really can't put things into the Constitution because, the Constitution is a document that was ratified. It's an historical, they didn't go around using the term historical the way we do, meaning noteworthy. It's an historical fact that this document was ratified. Anything we add to it isn't part of this. It should come at the end. So Madison reluctantly agrees that, we'll add them on at the end. Then what should we add on at the end is the other question. And what Madison does, it takes all of the proposals the states had made during the ratification process, as well as proposals like from the Pennsylvania minority, also all of the state declarations of rights. And he comes up with like 140 or so different proposals that are out there for amendment. And from this, he and the Congress come up with 12 amendments to add to the Constitution. Okay. Does anyone know what the first one is? No, it's not the right of speech. The First Amendment as proposed, what? No. See, this is the problem. We all know what we think of as, yes, sir. Exactly. Yes. The first one deals with the size of Congress, how big the Congress should be. It's a rather cumbersome thing because there was a sphere Congress wouldn't be representative enough, so the first proposed amendment says, deals with the size of Congress. Okay? Second one, anyone know? So if you actually go to the National Archives, or actually now you can go to the Commonwealth Museum at Columbia Point and see one of the original printings of these articles of amendment that were sent out to the states, and you'll see, we look at Article 1 and expect to see freedom of speech, freedom of religion, and what we see instead is this rather complicated mathematical formula. The second one is no law varying the compensation for the services of senators and representatives shall take effect until an election of representatives shall have intervened. There was this fear that these guys were going to get into Congress and start raising their salary. Okay, they cannot do that unless there's been an election. That way, if we don't like the fact that they've given themselves a pay raise, we can vote them out, and they won't get the benefit of it. Now, these first two amendments were not adopted by the states in 1789. Three states, in fact, three of the states did not adopt the Constitution, at least three. Massachusetts did not, Connecticut did not, Georgia did not, but enough did to carry into effect 10 of the 12 amendments. I know I'm getting too complicated here. You're trying to keep track of all of this stuff that's interesting but not that useful to you. So enough states ratify 10 of the amendments to make them part of the Constitution. These first two do not get enough support. So we're not added to the Constitution until the 1980s, actually, the second one. In the 1980s, believe it or not, members of Congress thought it would be a good thing to raise their salary, and they never had done it before there had been an election. They always said, okay, this will take effect after the next election. But in the 1980s, these really smart guys in Congress said, why do we have to wait till an election? We might get defeated. We want to get the benefit of this now. So they raised their salary, and some other smart guys, undoubtedly some smart women too, read these original 12 amendments and said, hey, you know what? James Madison thought we should prohibit Congress from doing that. And so the states then in the 1980s began ratifying this amendment, and it took effect in 1992. Okay? So in some ways that is the second article of amendment. It's also the 27th article of amendment because it's the last one to have been added. Then the third one is Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and petition their government for a redress of grievances. Okay, so Congress shall make no law establishing a religion, prohibiting the free exercise of religion, or abridging. So what does that mean? No state religion, no federal religion, I guess you could say. And there's a big debate about this. Samuel Huntington of Connecticut said, look, in Rhode Island, no religion can be established by law, and he could give a history of such a regulation. Indeed, the people there were now enjoying the blessed fruits of it. People in Connecticut and Massachusetts always regarded people in Rhode Island as depraved because they didn't have an established church, and they could do whatever they wanted. And Huntington certainly didn't want that kind of thing to happen on the federal level. And James Madison said he was actually more worried about the example of Connecticut, where there were Congregationalists and Episcopalians combining to coerce contributions from everyone else through force. Big debate about this in Congress in 1789 about the blessed fruits of religious freedom in Rhode Island. And incidentally, when a New England Congregationalist talked about blessed fruits of something in Rhode Island, he's being sarcastic. Okay, so there's that provision. And abridging the freedom of speech or of the press, Congress can't make any law about that. No comment on this. Or the right of the people peaceably to assemble, petition their government for a redress of grievances. Now, very interesting set of rights which have been combined here, or sets, not rights necessarily so much as prohibitions on government action, which what we'll call the First Amendment guarantees. Okay. Second one, much less controversial. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. What's that mean? There are a lot of people who are debating what that means. Yes, you're right. And people, well, this actually, look at the order these are in, and there is some reason for this. A number of the states propose something like this, or actually two things like this. One of the biggest arguments against the Constitution was it will allow Congress to create a standing army. Congress will have the power to arm and discipline the militia, which means essentially Congress could disarm the everyday people who are the first line of defense, not only against foreign enemies, but against potential domestic tyranny. So this amendment actually combines two ideas that come up from the various anti-federalists as well as others about Congress's power over the militia. And so it has this preamble. We agree a well-regulated militia is essential to the security of a free state. That means we're not going to have a standing army. But in order to guarantee that, now one thing that you should bear in mind here, and this is kind of a side note, many of the state proposals, for example, the Pennsylvania proposals and even the state bills of rights, use the word ought. These various rights ought not to be infringed or ought to be protected. This does not. None of these amendments use the word ought. Shall, which is the imperative, or more of an imperative than ought. So the right of the people to keep and bear arms shall not be infringed. Now, there's a big debate now. Does that mean an individual right or a collective right? I'm pretty sure it means an individual right. Otherwise, it would have said the right of people in a state militia to keep and bear arms shall not be infringed. So, what do you think?
Fundamental.
Yeah. I was doing a teacher workshop, this group on the Bill of Rights, and they go around and ask teachers, for first exercise is the teachers list what are the rights that are really important to them. And usually the guy said they get the same ones, except once in Texas, one of these guys wrote, the most important was the right to keep and bear arms. And he said, you give me that one, I'll guarantee the others. So, okay. Amendment number 3, no quartering of troops in private homes. Okay. To my knowledge, no one ever referred to this one until 1965, and it didn't have anything to do with quartering of troops. A year or so from now, we'll be talking about the 20th century, and we can talk about it then. Number 4, searches and seizures. That's actually a very interesting one. It comes out of the Lechmere case of the 1760s. You may recall James Otis's argument about that. Let's just see. Some of you may know this one by heart. Does anyone know this one by heart? Okay. The rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. It's fairly specific. Your right to be secure against unreasonable searches and seizures. Okay, if it just said that, there could be a debate. What's reasonable? What's unreasonable? I'm sure there will be a debate, but then it says, no warrants shall issue but on probable cause, supported by oath or affirmation. That is, whoever wants to search has to give an oath saying, I have probable cause to think that this guy has this stuff that we're looking for, but I also have to list what it is and where it is we're going to go. Very interesting article, protecting your right against the intrusive power of the state. Then number 5. By the way, do you want to keep going through these, or have you read them on your own? I mean, I can see if you're ever nominated for the Supreme Court, I hope you will have read these before and not just say, oh, gee, let me look that up, Senator. Okay, number 5, another list of protections of individuals who are, let's see, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Okay, grand jury. Except in cases arising in the land, naval forces, or in the militia, when in actual service in time of war or public danger. So that's one right. Indictment by a grand jury rather than by a special prosecutor or some prosecutorial court. Okay. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. This is what we call double jeopardy. You can't be tried twice for the same crime. Nor shall be compelled in any criminal case to be a witness against himself. And this is what people mean by pleading the Fifth. The Fifth Amendment gives you a protection against self-incrimination or of being a witness against yourself. Okay? Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Okay, fairly straightforward. Number 6, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. Why do you think they have this? The trial has to be in the state and district where the crime was committed, and that district has to have been previously ascertained by law.
To prevent people from going from one state to another, or from one county to another.
Which people from going from one county? Yeah, you have too many friends in this town, so we're actually going to try you somewhere else. Okay, it's quite a big protection here. And to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This is amazing. In all criminal prosecutions, this is. Compulsory process for obtaining counsel. Okay, witnesses in your favor, you have to be confronted with the witnesses against you. Okay. Number 7, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. So, there have been this big argument. Civil cases, there's not a guarantee to trial by jury, so this says, yes, in suits at common law, there can be a trial by jury. And there must be a trial by jury, I should say. And no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. So a jury makes a determination. You can't have another court saying, well, you know, we looked at the same facts the jury did, and the jury was wrong. We think you did it. So the jury, big thing here. Excessive bail shall not be required, nor excessive fines imposed, nor, what does excessive mean, by the way?
Did they define it?
Well, no, it says excessive.
They didn't define it.
No, they didn't.
Because I see murder cases today,
Yeah,
$50 million bail.
yeah.
That could be excessive.
Well, sure, if you were the person who did it, or I'm sorry, were accused of doing it, but there may be a reason for doing it as a threat of flight. I mean, the purpose isn't for us to get $50 million out of you, it's to keep you from fleeing. Do you need a bail bondsman, by the way? Okay. But it doesn't say what excessive is. Okay. Nor cruel and unusual punishments inflicted. So what does that mean? Cruel and unusual. So do you think that's cruel, and or do you think it's unusual? Okay.
I mean, would you want to die? I mean, do you want to...
Well, of course not, but no, I wouldn't want to die, but I know I'm going to.
No, even the thought of just have a time frame.
Okay, so this probably isn't a good time for us to have a discussion of the reasons for the death penalty. I'll recommend a good book for you by Louis Major called Rights of Execution that's about the death penalty debate at this period, which actually was a pretty big debate. But is that cruel and unusual? Yes?
Maybe being like real crime and you can't execute the death penalty for like stealing something.
Yeah, that might be cruel, but if you kill someone else, should you? I mean, I'm not advocating this, but
Nothing about the death penalty thing, but more just
yeah, okay, because you have this term, unusual, an unusual crime, or an unusual punishment.
Or for example, what we noticed sometime in Iran, a little boy his hand was crushed
Yes.
because he just took a piece of bread.
Yeah. Under a lot of Islam, some of Sharia law is you cut off the right hands of thieves to prevent them from stealing.
Put actually
Yeah.
next
Crushed.
to a car so that a car could
Yeah.
come and crush.
So you dispute the method or the punishment? Yeah.
And the punishment.
Okay, so you wouldn't say, okay, if we found a better way to crush his hand, then no.
There are other ways
Yeah,
to
yeah.
discipline.
Sure. No, I agree. I agree.
That method is
Okay, so I'm pretty certain that would be forbidden here under cruel and unusual, but it raises another question. What to us may seem cruel and unusual, and quite frankly, capital punishment has been quite unusual in the Commonwealth of Massachusetts for the last, I don't know what, how long has it been? Since 40 years maybe since someone's been executed, at least in Massachusetts. But does it mean what is cruel and unusual to us, or what was cruel and unusual in 1789? I don't know. That's a question that is, again, it's one of these other issues that's very much open to debate. Okay, so then you have two more. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. You'll recall that James Wilson had said, if you list some rights, that means you're creating a government that could infringe them. If you leave other rights off the list, that means those are up for grabs under this government because you've listed these rights. Well, this says that's actually not the case. The fact that we have enumerated some rights doesn't mean that others are denied. Okay? And then finally, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Okay? So powers not delegated to the United States are reserved to the states or to the people. Doesn't say, well, gee, they forgot to put this one in. They probably wanted us to have this power, so we'll take it. Any questions on this? Are you happy? Happier now than you were? Anti-federalists among you? Okay, good. Now, then, we have the House of Representatives, then, establishing the apparatus of the federal government, also passing the Judiciary Act of 1789, which created the Supreme Court and then district court judges in pretty much in each state, and doing these other, and also the Bill of Rights. And this is a full legislative agenda. Then the Senate actually was left with a considerable amount of time on its hands, and this was kind of a dangerous thing for the senators. Still is, I suppose, a dangerous thing for senators to be left with time on their hands. But what happened in the first session of the Senate is worth thinking about, because the presiding officer of the Senate, John Adams, introduced a debate, as Adams wanted to establish the proper tone of government. He wanted people to respect the government that was being created out of the whole cloth. And so Adams proposed a number of things, and one was he worried about what people would call these various public officials. Adams was conscious of his role, and he was conscious of his role as the vice president, that he was an executive officer. The executive branch, of course, is the branch with power. And so Adams, and he came to his official duties as presiding officer of the Senate, would wear a ceremonial sword as part of the vice presidential uniform, as a way of getting people to see the dignity and the majesty of the government. He also thought, and this was actually a big debate, well, what should you call the president? Anyone thought of that? Remember, Adams was really conscious of roles of government and also about the reputation of the United States abroad. And every cricket company, every fire company had a president. Some of you may be presidents of things. Is anyone here a president? So I am a president. So you call me Mr. President in some regards. Well, how does that differentiate me from the chief executive of the United States? He's also a president. What a bunch of buffoons will look like. And think about it. Adams had been the ambassador to the court of St. James. The King of England's title. Anyone know what the King of England's title was? His Majesty George, by grace of God, King of England, Ireland, Scotland, France, Wales, defender of the faith. And then it goes on. In the 19th century, the Queen becomes Empress of India. Okay? So really an impressive and imposing thing. The Emperor of Ethiopia, whom some of you may remember, his title included the phrase Conquering Lion of Judah. The King of Spain, His Most Christian Majesty. His Most Catholic Majesty. Okay? The King of France. The King of France was Louis, King, by grace of God, of France, Britain. His Most Catholic Majesty, or was it Christian? I always get them confused. Now, the king doesn't just wake up one day and say, hey, I want to be His Most Catholic Majesty. Or King of England doesn't say, hey, I want to be the defender of the faith. That is a title bestowed upon him by the Pope. Okay? You don't just say, hey, this is what I want to be. You have to be given this title. It's a very imposing thing. And when an ambassador presents his credentials at a foreign court, he announces who it is who has sent him. Okay? So it's a very imposing title given. And he actually represents that entity, that august being. And most of us would be blinded just to look upon him. And then you have someone coming in saying, I've been sent by the President of the United States. He's going to get laughed out of Europe, right? What a joke this is. So Adams thinks we need a more magnificent title for the president that actually conveys the difference between an elected president and one who has this office by birth. So Adams proposed the title should be His Elective Mightiness, the President of the United States and Defender of their Liberties. Now, that conveys it all. He's a mightiness, but he's an elective one. And he presides, but he also defends your liberties. What do you think of that? It's good, yeah. And he says, at home, no people are more fond of titles than Americans, which I think may be true. So this sounds pretty good. And he also says, this may be nonsense to a philosopher, but so is all government nonsense to a philosopher. But here you need a tone. You need to set the tone of government. And Adams is determined that it have a tone that people will respect, but also will understand this is an elective thing. Someone suggested that perhaps the vice president's title could be His Rotundity. And they actually spend several weeks debating this, what the president should be called, and finally they come up with the president. Okay? Washington was conscious of the fact he didn't need a fancy title because he did command respect. And Washington had good sense to stay out of this debate. Although Washington did have every week a formal levee, a way for people to come and see him. And the staff would draw a line of chalk on the floor where the president would stand, and his official family, that is the executive officers, would also stand. People would come in, shake hands, drink tea, and then go away. So this was a formal opportunity for you to meet the president. Mrs. Washington would also have a formal levee once a week for people to come and see Mrs. Washington. There's other issues at work here, too, because Washington, he stays out of this whole debate about the title. He doesn't need it. But there's another problem. As I mentioned, Washington coming to the Senate to ask for advice. The Constitution doesn't say he should do this, and then Washington doesn't after his first disastrous attempt. But the Constitution does say that from time to time the president will report on the State of the Union. Okay? So this is a tradition that begins with Washington, where he will inform Congress of the State of the Union, or will deliver an annual message. And so Washington is going to deliver an annual message telling Congress what's what, and he may suggest things for Congress to look into. But Congress has something of a problem with this before Washington even shows up. How is he going to get into the room physically? I mean, here we all are, the congressmen. We're sitting here waiting for the president to tell us what the State of the Union is. Should he, just walk in, knock on the door? How will he get in? You haven't given this any thought. See, this is the kind of good thing John Adams had time on his hands to think about these very problems. Because the president is coming to tell us what the State of the Union is. And actually, we know he is coming because he had a speech written for him. Washington was conscious of the fact that he wasn't a great writer. He always was good at finding people to write things for him, people who knew the tenor of his thought. And many of his speeches and other public papers we know were written by Hamilton. This first message to Congress we know was actually written by James Madison. So we know he's coming because Madison has just spent some time with him coming up with a speech. So we know he's coming. What should he do when he comes into the room? Yes? Okay, the governors would do something similar, perhaps. Remember, the governors in the colonial period had represented the king. So yes, they would address the legislature, but they're actually speaking in place of the king. So if we want to follow that particular model, we wouldn't so much be thinking, what's the governor of Massachusetts do, so much as we would think, what does the monarch do? Because in Parliament, the monarch actually opens the sessions of Parliament by giving a speech. And they have a special chair for the monarch to sit in, because they don't want him just standing around waiting to give his speech. It's a formal proceeding where the monarch comes and delivers his speech, and he does have a special chair to sit in. And in fact, the chair is always there, and you can address the chair, too, in Parliament. Do you know what you call the chair that the monarch sits in, by the way? A throne. Okay. So, should we have a special chair for the president so he can sit down when he comes in to deliver his message?
But they don't have it today.
Well, they don't have it today. You're very right. Do you think they would have had it in 1789? And somewhere along the line they said, we don't want Andrew Johnson to be able to sit down here. Let's take it out. This is actually something they decide in 1789. Will there be a chair for the president? Will anyone else be able to sit there? Should we have a canopy over it? Should people address the chair? And what do you think they say? No. It's the same answer they give to his elective mightiness. Now, they're not going to have a special chair for him. But then another issue comes up when he does deliver his speech. And then what happens is each house then debates how to respond to the speech. You know, today we have this thing where someone from the other party immediately gets on TV and says what was wrong with whatever it was this guy just said. There always has been a response. But in this case, it's a response from the body of Congress. So the senators get together and they decide how they are going to answer the president. And they have a big debate about how to begin. How would you begin this answer to the president, the response to his message?
One would have to address him with
Yeah.
some title.
Okay, so yes, so they've decided not to call him your elective mightiness.
No, I think that finally they decided on the words His Excellency.
Yes, Your Excellency, Mr. President, then what do you say? Next line. Yes.
You just read it like you're just saying like you're reading a letter. Dear Mr. President.
Dear Mr. President, whatever. Well, the senators thought they should say, thank you for your most gracious speech. What do you think of that? Anyone have a problem with that? No? How about the fact that Parliament always talks about the King's most gracious speech? It's not just a word you throw around. Gracious. You may call things gracious. I don't know if there was a twittering version of this, your radical speech. Well, maybe that would be actually the phrase they would use. So anyway, they say they're not going to call it a gracious speech. And the Senate also wants to talk about how he's helped to uphold the splendor of government. So the senators do come up with a response, which they then go and read to Washington at the house he is using in New York, and Washington then has a written response actually to them. Now, and the House of Representatives also comes up with their own response to Washington, and Washington responds to them. One thing you should know if you now go and read all of these different speeches is if you read Washington's address to Congress, and then you read the House of Representatives' response to Washington's speech, and then you read Washington's response to the House of Representatives, it will all seem it's a monotone, because James Madison actually wrote all of them. He did not write the Senate's response, but he did write Washington's response to the Senate. So you have this interesting multi-party conversation being carried on with Madison being the one voice. Okay, why don't we take a break at this point, and when we come back we'll get to more substantive issues, although we did cover a lot in this hour: Bill of Rights, executive departments, title for the president, and there actually is more.